When a restaurant or bar sells alcohol to intoxicated people, they are literally unleashing assassins on our roadways. And the one thing everybody needs to know is when they do this, when they are selling alcohol to drunk people to line their pockets and make more of a profit, there are laws to hold them accountable and make them pay for the devastation and destruction they cause. Now, make no mistake about it. This is not about punishing bars and restaurants for every bad decision their customers make. This is about stopping reckless, profit-driven behavior where bartenders and owners ignore signs of visible intoxication and they keep serving anyway, resulting in injury and sometimes death to completely innocent victims. And miraculously, the drunk drivers never seem to get injured when they maim or kill someone else. At worst, the drunk driver ends up in jail. Yet the trail of catastrophic pain they leave behind extends far beyond broken bones. Jailing the drunk driver will not help the victim pay their rent or mortgage, put food on the table, pay for their medical expenses, pay for their children's education, and worst of all, it won't pay for the funeral expenses. Families are left broke and traumatized, yet the only remedy available through our civil justice system is a monetary one. Now, a monetary award is supposed to compensate people for what has been taken away from them. But a life, a person's guidance and support to their family are completely immeasurable. Yet the family still needs to go on and needs to find a way to pay for all the things that have been taken away. They still need to pay their rent, their mortgage, put food on the table, education expenses, future medical expenses. They need to figure out a way to pay for the cost of living. In this video, I'm going to explain how to best maximize the recovery if you or a loved one have been injured or worse yet, killed by a drunk driver. My name is Phil Rizzuto of the Rizzuto Injury Firm. We represent clients who have been injured through the neglect of others all over Long Island, throughout all 5 boroughs in New York City, Westchester, and throughout the state. This includes representing families who have been devastated by drunk driving accidents, regular car accidents, construction accidents, falls, nursing home neglect, funeral home neglect, and any type of injury that is caused by another's negligence and irresponsibility. Now, regardless of the type of case, there are 3 factors that must exist in order to maximize the recovery in all cases. Whether it's a car accident, a fall, a construction accident, whatever it is, there are 3 factors that must always exist to get the best recovery. First is somebody has to be responsible. We call that liability or negligence. The second factor is there has to be an injury caused by someone else's negligence. And the third, there needs to be a deep pocket to pay for the damages caused. Usually that's an insurance company. Sometimes it's not. Sometimes you can go after the defendant directly. But they have to have a deep pocket in order to pay for the damages that were caused. The legal definition of negligence is the failure to act as a reasonably prudent person would under the circumstances then and there existing at the time of the accident. You could be careless, you could be reckless, but if you fail to act as a reasonable person would, then you are found negligent. Injuries could be economic injuries or physical injuries. They could be lost wages, they could be property damage, they can be medical expenses, they can be pain and suffering, but they have to be caused by the neglect. If you have an injury and it is made worse, we call that an exacerbation, and you can make a claim for an exacerbation of a pre-existing injury. And the third category is a deep pocket. Like I said, usually that's insurance coverage. If you're driving a car in New York State, the minimum amount of coverage required to operate a vehicle is $25,000. Now, $25,000 is the minimum. Vehicles could have more. They could have $50,000, $100,000, $500,000, $1 million. There could be excess coverage. There could be umbrella coverage. But the minimum amount required to operate a vehicle in New York State is $25,000. Commercial vehicles usually have higher insurance policies. Premises cases usually have higher insurance companies, at least $500,000. In most cases, it's $1 million. So these 3 factors must exist in all types of cases in order to get the best outcome. If you are in an accident with a drunk driver and you sustain catastrophic and life-altering injuries, you're most likely going to be limited to the insurance coverage that the driver has. So if you're maimed, then you need to make alterations to your house in order to accommodate you. If you're wheelchair bound and need to install ramps and make the house handicap accessible, you are going to need a lot of money in order to do that. Worse yet, if your loved one dies and they were the sole supporter, they were the breadwinner of your family, and you lose that income and you lose their financial support, let alone their emotional support, in most cases, the insurance policy of the driver who caused the accident and who is drunk is not going to be sufficient in order to compensate you or the family for the devastation that they caused. In New York, there is a law called the Dram Shop Law. It makes vendors legally responsible if the vendor served alcohol to that person while they were visibly intoxicated or under the age of 21. The term dram shop comes from an old word called a dram. A dram is a small unit of alcohol sold in taverns. Now, in order to establish this claim, an individual must prove they were injured by an intoxicated person. They must also prove the vendor served alcohol to that intoxicated person. Now, this law applies to the unlawful sale of alcohol by commercial establishments such as bars, restaurants, and liquor stores. So what constitutes an unlawful sale? Well, if an establishment sells alcohol to a person who is under the legal drinking age, in most states it's 21, that constitutes an unlawful sale, regardless of if they were intoxicated or visibly intoxicated or anything else. If they are under the age of 21 and they are under the legal drinking age, that is an unlawful sale. If an establishment sells alcohol to a person who is visibly intoxicated, that is an unlawful sale. You can also make an argument that an unlawful sale exists when an establishment sells alcohol to a habitual drunk. Signs of visible intoxication could include stumbling, loss of balance, slurring your speech, being belligerent, showing signs of aggression, falling asleep at the bar, repeating yourself, forgetting things. We've all been there and we've seen it at bars, at restaurants, at concerts, at the beach, in the street. Wherever it is, you can tell when a person is intoxicated and has had too much to drink. And if you can tell, the bartender can tell. And if the bartender can tell and they keep pouring, that is unlawful service. Now, there has to be a causal connection between the unlawful service of alcohol to the intoxicated person and the injury. If you serve somebody who's intoxicated and they go out and cause an accident, but the person is already driving with a broken arm, there is no causal connection between you serving the intoxicated person and the injury. But if there is a causal connection between the establishment serving the intoxicated person and the injury, that will go a long way in proving the case. Now, injuries are not just physical injuries. They can be psychological injuries. They can be loss of income. They can be medical expenses. They can be cost of medical testing and treatment. They could be prescription medication. They could be expenses for having to hire household help or renovating your house as a result of the injuries that you have sustained caused by the drunk driver's negligence. And they are not only limited to the injuries from the date of the accident up until the date of the recovery or settlement. They can include your injuries for the future, over your life expectancy. For simplicity purposes, I use 80 years as a person's life expectancy. But there is a book called the Patent Jury Instructions, which has a table which will give you a person's life expectancy. To round it off, I say 80 years. And you can make a claim for whatever your potential damages are over your life expectancy. So if you're 40, over the next 40 years, if you're 50, over the next 30 years, if you're 20, over the next 60 years. And how do you do this? Well, you get reports from doctors, maybe from an economist that may have to project what your income was and what it would have been over the future and what you lost from it. What the cost of future medical devices are in order to help you just live your activities of daily living because you can no longer do them as a result of the injury sustained from the drunk driver. These expenses add up and could add up to millions. Now, in some cases where the conduct is so egregious, you may even be entitled to get punitive damages. Punitive damages are damages that exist to punish the person who is negligent. So if the establishment clearly sees a person is drunk and you have clear and convincing evidence that they were serving this person and contributing to them getting further and further and further drunk, and it is so overwhelming and their conduct was reckless and endangered the public, clearly you may be entitled to punitive damages, which is immeasurable. What is the evidence that is required that you need in order to establish a claim against a commercial establishment for violating the Dram Shop laws? The real short answer is anything and everything to show that the person was at the establishment served them alcohol, that the person was visibly intoxicated, and they went out and caused injuries to somebody else. Actual evidence includes witnesses, getting witness statements from people that were in the bar. They saw the establishment serving the person. They saw the person was visibly intoxicated. When he left, he was visibly intoxicated, or she was visibly intoxicated. Video surveillance, video footage at the bar. We had a case where we had video surveillance of somebody at an ATM machine that went to the ATM machine like 3 or 4 times during the course of a night, withdrawing money and going back to the bar and purchasing alcohol. Now think about it. When you're in a bar and you're buying drinks, you don't get a receipt unless you're paying for it on your credit card. If you're paying cash, you're not getting a receipt for the drinks that you caused. So you really need to do some investigation and put the work in to establish that the person was at the bar and buying drinks and that they were getting visibly intoxicated. Witnesses could include bouncers, people that worked there, other bartenders, the actual bartender who was serving the person, whoever the person was with, their associates, their friends, to give you statements as to what was happening, how many drinks the person had, what types of drinks the person had, who were they with, how quickly were they consuming the alcohol, in what period of time did they consume a certain amount of drinks. Now, in some cases, when there's an accident and the drunk driver is brought to the hospital, they will do a blood test and they will determine what the person's blood alcohol level was. Or if there's an accident, the police come and the police do a sobriety test, or they do a field test, or they end up doing a breathalyzer test. That is more evidence to show that the person was intoxicated. Now you have to tie their intoxication into the fact that they received the alcohol from the establishment that they came from, the establishment that you want to sue. Now, and why do we do this? Why do we put so much time and effort and work into establishing a claim under the Dram Shop Law against a bar or a restaurant or any commercial establishment? Again, we go back to the third factor that is required in order to have a successful lawsuit. You need a deep pocket, and those establishments usually have higher amounts of insurance, more insurance than the drunk driver would have. So in order to maximize your recovery, it is so imperative that you get all the details, that you find out where the drunk driver was coming from, who he was with, what he was drinking, where he got his alcohol from, and you make a claim against the establishment that served him so you can get the higher insurance coverage to help compensate you for the injuries and the damage that this drunk driver has caused. One of the worst cases I have handled in my career involves a man who was about 48 years old. He was killed by a drunk driver on his way home from work, and he was the sole supporter of his family. His wife was disabled. He had 3 young children, ages 6, 8, and 12. They all went to private school. And on his way home from work, within a mile from his home, a drunk driver blew several red lights, crashed into him, and he died. 48 hours of the accident. The driver's insurance company tendered his insurance policy limits, but they were only $100,000. When there is an accident and there is a fatality, the police do a comprehensive investigation. The police department did a lot of the legwork for us and investigated the matter. I have to say the Nassau County Police Department, the Nassau County District Attorney's Office cooperated with us fully, and they did everything they could to help us out. But during the course of the investigation, we found out that the person was drunk. We found out where he was coming from. We had video footage of all the traffic lights on the roadway and showing that the driver just went through one light after the other and after the other. By the way, that also helped show that he was intoxicated because he was blowing through these lights at like 75 to 90 miles an hour. So we could not accept the policy limits of $100,000 from the driver because ultimately it was the driver that caused the accident. And if we would have settled the case and took the $100,000 from the driver, we would have gotten almost nothing from the bar where the driver was coming from and who actually served him the alcohol, causing his intoxication. The bar took the position that the person was intoxicated when he went in, that We don't know where he went between the time when he was at the bar and the accident was caused. They don't know what other substances he may have been on at the time of the accident. And the hospital records showed that his blood alcohol level was extremely high. So once we had the police file, we knew where the person was coming from. We were able to get video footage from the ATM machine across the street that showed several withdrawals, as I mentioned earlier. We were able to get witnesses from the bar to put the defendant, the person who caused the accident, the drunk driver, at the bar and say he had, I think it was 5 or 6 drinks within a matter of an hour and a half to 2 hours. What he was drinking was hard alcohol. We had witnesses establishing that he was visibly intoxicated, that he was drunk, he was slurring his speech, he was losing his balance, he couldn't stay on a bar stool. Yet the bar fought us. They claimed, well, you couldn't prove the causal connection to the injuries and to his death because there was a gap between the time that he left the bar and the time the accident happened. But we were able to establish a timeline between witnesses at the bar, the ATM receipts, the distance between the bar and where the accident occurred, that really wasn't that big. I think the gap turned out to be about 20 minutes. We ended up settling with the bar very close to their insurance policies of $1 million. They paid just under, because they offered just enough money for us not to say no, take the risk of having to go to trial, and who knows what would happen at trial. Nothing is ever guaranteed. But the bigger factor was the time it would take us to go to trial. We were probably about 2 years away from trial. We were already litigating the case. We were in our 5th year of litigating it and 2 years away from trial. And the family literally needed the money to survive. The mother was disabled, the children were young, and they needed the money to pay the mortgage, put food on the table, pay the kids' educations because they were going to private school, and really left them with no alternative other than to accept the settlement for a little less than what the insurance policy limits was. So it was a no-brainer. If we had to go to trial, we would have had to pay the experts to come in and testify anyway. So the net result would have been the same under the best case scenario, and we would have had to wait another 2 years probably to get there. And then, like I said, you never know. Witnesses somehow move. We can't contact them. So there is always a risk going to trial. So we got a very good settlement, very close to the policy limits. The client was ecstatic, and this was the most devastating case, I believe, that I've ever handled in my life. If you or you know somebody who was ever injured by a drunk driver and have questions about this or any other matter, please give me a call at 800-666-5555. We are here to help. If we can help you with your issue, I will find somebody that can, and I will put you in touch with somebody that can help you. But if anything related to personal injuries, car accidents, construction accidents, products cases, cosmetic injuries, nursing home neglect, we do all of that. If you found this information useful, click the like button, subscribe to the channel, and follow for more, and I will see you next time.